There was a time when the Supreme Court was meant to be a guardian of balance, a check upon power, not its source. But over time, its reach grew beyond the intent of those who framed it. In Marbury v. Madison, the court claimed for itself the power to strike down laws, a power never written, yet forever assumed. In Citizens United, it declared that wealth itself could speak as freely as people, and so, the public square was drowned in the voice of money. And in Trump v. United States, it placed the president beyond the law's grasp, granting immunity where the Constitution never promised it. Behind the marble walls, decisions whispered in darkness, the shadow docket, shaping lives without reason or record. In their silence, justice withered. When law becomes power and judgment becomes dominion, justice descends, not in wrath but in reminder. Even the highest tribunal must face the truth of its excess. Lady Justice raises her sword, and with a stroke of divine light rendered in brilliant white ink, the courthouse splits down the middle. Lightning bolts drawn in radiant cross-hatching illuminate the scene. Scrolls and papers swirl around the judges in detailed line art spirals. Yet from the dust rises a question for us. Shall we only swell its ranks and call that reform? Most would merely expand the court, binding its fate to the whim of a single president. Are we to stake the constitutional order on the advent of a perfect leader? Or shall we cut the court asunder? So we begin anew, not by abolishing the court, but by rebalancing it. The number of justices shall be twice the number of judicial circuits, binding the court to the map of the republic itself, and the apportioned equally between two divisions, the orders and the opinions divisions. The first, appointed by the governors of the states within that circuit, shall sit in the orders division, to manage certiorari, oversee inferior courts, and grant or deny preliminary relief where law meets circumstance. Together they reflect both the national and the federal, both the unity of law and the diversity of states. The second, the opinions division, appointed by the president, deliberates deeply. It rules on merits, on questions within the bounds of law and constitutionality, and gives the nation reasoned judgment in the light of day. And when the most fundamental of questions arise, when laws are to be overturned, or precedent reshaped, or constitutional meaning redefined, the divisions shall sit as a whole, and the unified Supreme Court shall convene and rule as one. In full vestment, all justices deliberate together. Yet even structure must answer to philosophy. Each division holds an odd number of justices, for human questions demand decision. When lives hang in the balance, the court must act. But when the full court sits as one, when the question reaches the roots of the republic itself, the unified Supreme Court justices sit in even number. For the most foundational matters do not yield easily to verdicts. They require humility. When the vote divides, it leaves the law unchanged, an act of restraint, a gift to posterity. Thus, the court's design honors two virtues long forgotten: decision when necessary, and deference when wisdom demands. Through this form, justice learns proportion, power learns modesty, and in that balance, the republic learns again to see itself, not ruled by the court, but refined through it.